Okay, welcome back to another episode of Litigious, the #1 podcast in the world for discussion of legal stories in the news. This is take two because I accidentally referred to our podcast by its prior name on take one, so forgive me, and we will talk litigious this week. As always, this podcast is brought to you by Alo Peterson, a plaintiff's serious personal injury and employment discrimination law firm with offices in New York and handling cases in New York, Vermont, and Massachusetts. If you have questions, visit the website at DerazioPeterson.com or hit us up on Instagram at DerazioPeterson. If you like the podcast, please subscribe, like it, share it with friends, and if you have questions, you can hit us up again at Litigious Podcast on Instagram. So this week, some slightly less sort of upsetting stuff to talk about from the prior couple weeks. And we will start off with an update and discussion of some legal maneuverings in the It Ends With Us, Blake Lively, Justin Baldoni lawsuit, which relate to, in multiple cases, some of the issues that we run into in our litigation practice as well. First being, sometimes you have to serve a subpoena, and when you have a subpoena to serve, you hire a process server. In this case, a process server apparently tried to either break into Travis Kelce's house or at least was illegally on his property. And what happened there?
The process server was trying to serve allegedly a deposition subpoena on Taylor Swift and apparently tried to hop Travis Kelce's fence in Kansas, right? Like they're Kansas City, Kansas, not Kansas City, Missouri.
That's a good question. Sure.
Are the Kansas City Chiefs in Kansas?
I mean, I should know the answer to I should know the answer to that.
Google search. Anyway, so he hops Travis Kelce's fence or tries to hop the fence. He gets arrested. P.S. It's 2:00 in the morning. And a little bit, I mean, I think we're going to get into some of that. What?
You threw me off with Kansas City, Kansas. It's Kansas City, Missouri.
I think there is a Kansas City in Kansas. No?
I mean, there might be, but that's not where the
They
Chiefs
said his
play.
house was in Kansas, unless the article I read was just wrong. They described, maybe they meant to say Kansas City. It literally said Kansas, so like the state, like the Wizard of Oz.
No. Go ahead.
Is there a Kansas City in Kansas, though? There is.
I mean, there might be, but Arrowhead Stadium, which is where the Chiefs play, is in Kansas City, Missouri.
Okay.
All right. We've now been sidetracked. So go ahead. They broke into his house or
Yes,
broke onto his property.
I just want to say there are 2 Kansas cities.
All right. I'm glad we've established that.
Okay.
Okay.
So he jumps over the fence, he gets arrested. It's 2:00 in the morning. I feel like, first of all, I think this was not prudent regardless, because wouldn't you be afraid to be like shot off of someone's property by a security guard or something like that, or by the homeowner themselves? I mean, that doesn't seem beyond the realm of possibility. Someone is jumping your fence at 2:00 in the morning. Especially somebody like her, because one of the things that I thought was alarming about this is that poor Taylor Swift has a stalker who I think is supposed to be kind of monitored in some way and has apparently dropped off the face of the earth. So I feel like that's pretty scary. And then to have somebody kind of like jumping over your fence. But anyway, he was arrested. I guess he was an ex-police officer turned process server. And like a process server is allowed to knock on your front door. They can, personal service is one of the several different ways that you can be served with either a complaint and a lawsuit or a subpoena. But typically that means they're kind of handing it to you, or again, like knocking on your door, but you still have to abide by property laws and things like that. And, I would say that it would not be a great idea to go over someone's fence in the middle of the night. Obviously, he was
We,
arrested, so that was wrong.
yeah. So in most lawsuits, when you're in a lawsuit, you take a deposition, which is a way that you sit down and ask questions of someone formally. And you take a deposition by serving a deposition notice. And if it's a party to a case, they have a lawyer, and you just send the deposition notice to the lawyer, and you agree upon a time, and you have the deposition. In some cases, once you're in a lawsuit, attorneys have the right to issue subpoenas to bring basically anyone in for a deposition within reason, typically within the state. If you want to get it from out of state, there's a way. It's a little more complicated. Um, if you know someone has a lawyer, ordinarily you would just reach out to the lawyer to coordinate the deposition, even if it's a non-party witness. And then in many cases, the lawyer will accept the subpoena or notice on behalf of the non-party, and you just move forward mutually agreeable time. Um, that's A. B is I've used a lot of process servers in my life. I've never seen one hop over somebody's fence at all hours of the night to try to get service. However, I do have a story about a private investigator who was staking out the property of a party who was claiming to be injured at one point early on in my career. And the process server was laying in the ground, like sort of hiding out in the thicket like you would if you were hunting. And apparently, somebody else was out in the woods and urinated on him, whether that was intentional or unintentional. Yeah, so that actually happened.
Yeah, didn't you have a
Um,
Repo Man case too?
yeah, I mean well, that was more of a sad case. That was a a motor company went to repossess a car, and as it was being pulled away, the person who had owned the car and had failed to make the payments came home and jumped on the back of the car, fell off, and actually got run over and killed. Um, and that was a case that we litigated. I was defending one of the parties in that case years ago, and we litigated that for a long time. So that was messy. But yeah, so people do interesting things in these scenarios, but this all sounds a little weird, particularly under the circumstances. I mean, I would think that if you're trying to get a deposition of somebody like Taylor Swift in a case like that, that you would at least have information or access to information about her lawyers, and that you would try to coordinate, which does bring us to another thing we're going to talk about momentarily here. Um, I guess we can just go into that now. This will be fall into the headline of excuse me, fall under the category of misleading headline of the week. The headline says basically, uh, Baldoni team request to deny Taylor Swift, request to depose Taylor Swift denied, which is technically accurate, but the reason for the denial is basically because they waited too long in the course of discovery during the case, and the judge would not extend the deadline to allow for Taylor Swift's deposition. I'll let you get into kind of the meat of that argument, but basically the way it works is that when you file a lawsuit, um, the case gets assigned to a judge at some point, and the judge typically puts in place a scheduling order, which says, the parties have to exchange paper documents within a certain period of time. The parties have then a certain period of time to take depositions of parties, certain period of time after that to take depositions of non-parties, and then the attorneys have to certify that the case is ready for trial, typically within a certain period of time. These deadlines get established in every case. In probably 80% or more of the cases, there is an extension of those deadlines at some point just because of logistics. Attorneys usually mutually agree. Sometimes they don't, but even when they don't, judges will typically extend those things out. Uh, Only one of two reasons would typically arise where a judge would absolutely refuse to allow somebody to extend a discovery deadline. Number one is the judge is just a miserable, difficult judge, which does occasionally happen, although less so now than when I started practicing, even. And the other is the situation where the judge is fed up with the behavior or positions that one party has taken and is just going to basically saying, "I'm not going to give you another inch. You've lost all your goodwill here." And I'll let you explain why in this case it's probably the latter.
Yeah, I think reading between the lines in this case, you feel that it probably is that the judge either doesn't really think that Taylor Swift's testimony is super relevant to the case anyway, Because I think it's relatively rare that a judge will, even if they do it begrudgingly, will not extend a deadline for something that is genuinely kind of material in the case. But in this situation, I think Taylor Swift's involvement is sort of tenuous at best. She does have lawyers. Her lawyers happen to be from a law firm that's on the other side of one of our cases right now. So she does have lawyers that have interjected a couple of different times in this case. They made it very clear that they don't think that her testimony is relevant, that she really didn't have anything to do with the production of this movie. And I think that it looks like Justin Baldoni's lawyer, and we've kind of touched on this a few times, might be playing a little bit, fast and loose with the circumstances, because from what I read, one of the reasons that they used as sort of an excuse for the discovery deadline extension was Taylor Swift's schedule, and basically seemed to have represented that Taylor Swift was agreeing to the deposition, but that her schedule wouldn't allow her to do it until after the current deadline had expired. Her lawyer came in and said, no, we have not agreed to anything, but if we are subpoenaed, this is what her schedule is. Now, do you want to spin that as being an agreement? Because would she be entitled to try to quash the subpoena? Yes. So theoretically, if she's going to accept the subpoena and show up when she's supposed to, or get involved in the scheduling, is she theoretically, quote unquote, agreeing to be deposed? Maybe. Or at least she's decided she's not going to fight it. But, my perception is that if the court doesn't really think this is super relevant or necessary, and they're not happy with you and how you've engaged in the litigation, they said, I think the decision was, in terms of not extending the deadline, was that they hadn't done their due diligence to get this done in a timely manner. So, ultimately, it doesn't appear that this will probably happen. If all of that is true about this process server, I'm sure that's not going to ingratiate them to the court very much either. Not that you necessarily are telling the process server exactly what to do. I tend to be a control freak, so if I'm worried about something being served properly, I tend to tell them very specifically how to do it and what to do. But that's not necessarily something you need to do. You can kind of leave it to their discretion on how to get it done. But I don't necessarily see that, ingratiating themselves very much.
Yeah, I agree. I'm sure it's probably, when you're a judge, you probably simultaneously enjoy this kind of a high profile lawsuit and also despise this type of litigation because it just swallows up so much of your time dealing with fight after fight. I can tell you my experience with judges is that when you make their life difficult, they are not pleasant to deal with, understandably. And they like when lawyers behave like adults and solve problems among themselves and aren't coming in all the time, looking for a referee. So I would imagine that given what's been happening here, that the judge is probably just fed up with the situation. One last issue in that case is there's an article indicating that Blake Lively has filed a motion or is intending to seeking legal fees after the dismissal of Baldoni's counterclaims against her. This was in New York, where it is not customary to get legal fees just because you win a portion of a lawsuit. There are several exceptions to that, but if you get a claim dismissed, it's not typically the case that you'd be entitled to legal fees. But why don't you kind of talk a little bit about that?
Yeah, typically when you recover attorney's fees in a lawsuit, it's because you are the plaintiff and you win under typically a statute that provides for attorney's fees. So in Blake Lively's case, Title VII, the sex discrimination statute, does allow the winner, meaning the plaintiff, to recover their attorney's fees. Now, typically, if you are the defendant and you are successful in having claims dismissed, which is the situation that this case is in, with Baldoni's counterclaims against her having been dismissed, usually the defendant in that situation is the winner, but is usually not entitled to their attorney's fees. There are some statutes where if the claim, I mean, there's some statutes where if the claim is so sort of out of bounds and lacking in merit, that a defendant might be able to make a claim for some attorney's fees. There's situations where the claim is even worse than that, where it's frivolous, where you could get attorney's fees, but we would call them in that situation like sanctions. In federal court, in order to get sanctions, you have to first give the other litigant the opportunity to discontinue the claims on their own. You can't just go to the court and say, this is a frivolous claim, I deserve sanctions. Even if the claim is dismissed, you have to give them, like, you have to write them a letter and be like, these are the reasons why this claim has sort of exceeded a claim that we think is going to lose, but has actually crossed the line into being frivolous. If if you pursue something like that, there are situations where you could get your attorney's fees. But yeah, I think it's relatively rare. I don't know. He had some California law claims in there, so it's possible that some California statutes might have like a prevailing party kind of attorney fee provision in there, but usually people are not recouping their fees in cases like this, even if they win.
Yeah, that's a bit of a misleading headline in itself. I can't think of a case that I've been litigating cases from roughly 20 years, and I can't think of a case where attorney's fees were awarded for a dismissal in a situation like this. Um, and just to the comment on sanctions, again, I've been doing this for a long time at this point, and it's actually pretty rare that you have to request sanctions against another attorney. I mean, the court can order them on their own. That's very rare. Um, I mean, I've litigated against some difficult people, and I've never even thought about. I shouldn't say never thought about, but I've never come close to requesting that they be sanctioned. It takes a lot, and attorneys are usually pretty respectful of one another enough so that they won't request sanctions. If somebody's completely over the top over and over and over again, making crazy claims, yeah, I mean, I suppose you could do that, and maybe that's the situation here where they're requesting these fees as sort of a slap on the wrist for what they they deem to be inappropriate or excessive behavior. But it is exceedingly rare that those types of things get awarded, at least in New York, in our experience.
Yeah, I
So
think the only case I've ever had before we started working together was when me and a few other attorneys from my old law firm got sued in the civil RICO action, being accused of some sort of like, I think it was like wire fraud or mail fraud or something, because the disgruntled person on the other side of one of our cases, like, just as anyone in litigation disputes, what is in an affidavit or whatever, everybody has their own side of the story, decided that, he, instead of just saying, I don't agree with what's in this affidavit, I'm going to put my own affidavit in, he sued us all more than once. In this, one was a RICO case, the other one was something else. I don't even remember what the other one was, but it was very annoying because I had to like put it on a mortgage application and stuff. Like, are you a party to a lawsuit? I was like, yes, unfortunately I am. And by the way, it's a RICO case, so now I sound like I'm in the mafia or something. But that's the only case that I personally remember doing in federal court. It's called like Rule 11, I believe. Where you really were like, this is frivolous, this is completely outrageous. Because in that situation, there was like a ton of case law that you can't sue lawyers. Because meanwhile, we're not the ones making the affidavit, right? So if something in there, is either they dispute or whatever, like we're just drafting it. Somebody else is, attesting that it's true and whatnot. And you're just doing the best, as the best you can based on the information that you have and that your client tells you. So there's a ton of case law that you cannot sue lawyers under RICO mail and wire fraud, because the wire was the fax machine. Like for that. So, like typically if something like that happens and there's a ton of case law out there that is already decided this issue, you tell the person like, this is a losing argument. We're going to be wasting our money fighting this off. There's no way you could ever possibly win. And then I remember and then I think we asked for an injunction as part of the sanctions that he could not like sue us again when the case was dismissed, which it was. But they denied that, and then we did get sued again. So we needed that.
Yeah, a couple comments on that. Number one, with the injunction, I actually feel like that's potentially like some kind of a First Amendment violation for a court to tell someone that they can't bring a lawsuit.
I think it can happen like under limited circumstances where you are like abusing the courts to an extent that at least on that issue, like you're done.
Yeah, yeah, yeah. I mean, of course, certainly, like you might not have standing to bring the suit. The other piece is, for the record, we should clear up is that the person who sued you was a pro se litigant. That means they couldn't get an attorney or didn't have one. And two, that all of the cases were dismissed.
Yeah, they were all dismissed.
And yeah, yeah. So,
Wrong.
and the funny part is that you were like an associate at a law firm. You weren't even like a named partner at that point,
Yeah,
right?
and
I
then
mean,
the
that was
second
even
time we
early.
got sued, I had already left and I was working
Yeah,
with you, and I had to ask them to like indemnify me. It just was like an annoying thing.
yeah,
But
yeah.
people don't really, if you are abusive with lawsuits and the courts and stuff, I think that's, I mean, not that we would do that ourselves, but I think one of the reasons why I take seriously when I file a lawsuit and when I don't is because I do have some perspective of the fact that it is, something that you have to disclose to people, especially if you're a professional. If you're a lawyer, you have multiple different points in time where you might have to disclose that you are a party to a lawsuit. Like if so like you have to get admitted into a different court or something like that. And you had like, I remember when I was getting admitted into the Second Circuit, which is the federal appeals court, one of those was pending, and I had to attach a rider to my application and explain what happened.
Yeah, yeah. I mean, when I applied to Massachusetts, I had to, well, fortunately, I was not being sued at the time, so I didn't have to say yes, but it definitely is something you have to acknowledge. All right, let's move on. In the news this week, the company Alo, which is a yoga brand, expensive yoga brand. What is it, like, similar to like Lululemon, right?
Well, I think like the Lulu people and the Alo people are like, you know, rivals.
Okay.
Like
I
our
don't own any
daughter,
Alo
so I
clothing.
happen to be primarily a cheapskate when it comes to athleisure and my gym clothes. So I don't tend to spend a lot of money on them because I only wear them to the gym. Like there's definitely like a category of women that are probably younger than I am who do walk around in, like attractive gym attire like in their regular life. So for me, it doesn't feel like it makes sense to spend, that much money, although I do understand that there's like a difference in quality certain things. Anyway, our daughter, on the other hand, who's 13, is very dialed in to what athleisure is in at the moment. And she had her Lululemon phase that was maybe like around the same time as what's that brand with we went to the
Fiore?
store. No, and like Height Ashbury. Oh my God, what's that called?
Brandy?
Oh, Aviator Nation.
Oh, all right.
Um, and then suddenly she was like, no, I have to have my sweatshirts and whatever have to be from Alo. So
All right.
anyway, but
Well,
yes, it's
speaking of
a
age,
nice yoga clothing
athleisure wear. Okay.
brand.
So speaking of age, Alo has been sued by a 42-year-old yoga instructor and influencer who apparently is very popular and was like their lead or one of their most famous yoga instructors for age discrimination. She is 42 and uh, claims that she was basically pushed out because her age no longer met the quote unquote Alo aesthetic. So what's going on with this?
Yeah, so I think this company used to be a little bit more under the radar, and then pretty relatively recently, like maybe in the last couple years, has definitely had kind of a branding push. And I think they have sort of like pop-up lounges and things like that. And they definitely, I think started to become much more prevalent in terms of their brand than, maybe prior to that, like you said, it was Lululemon that you kind of saw a lot of young women wearing. And there's been sort of a shift, and I think Alo has kind of come out as one of the more desirable brands. Then, obviously you see like a backlash where there's people who are like, no, it's horrible. And this other thing that, you don't have is better. But anyway, so I think she's alleging that in the context of this sort of rebranding kind of expansion that they are having, because I think they used to be a little bit more, small in their reach. And now they're really, like I said, with the lounges and things like that, they're becoming a lot more sort of ubiquitous. And her allegation is that as they have sort of done this expansion and rebrand, they have started to focus on much younger women as being sort of the faces of the brand. And she says in her lawsuit that they sort of said to her because I guess she was making a salary and bonuses and all of these things sort of started dwindling. And they told her they were sort of changing their focus. And she says that in the context of this company, changing our focus is sort of code word for discrimination, for age discrimination.
Yeah, we're going to be focusing on different things. So, the standard, this is, all right, well, this is in California law, or this is under California law. So the standard in New York is, well, and federally, how hard is it going to be for her to prove this case if it ever gets that far? Because probably it will settle.
Yeah, I mean, in this context, maybe easier than others. I mean, age discrimination has the highest standard under federal law, which is the ADEA, Age Discrimination and Employment Act. The standard in an ADEA case is but for causation, which is the highest level of causation employment case. Basically means like, this is the reason that you have to prove as the plaintiff, this is the reason. Contrasting that to sex discrimination, Title VII, the Title VII standard is motivating factor, which means that as long as one of the reasons why they fired you was illegal, you can, prevail in a case like that. It doesn't have to be sort of the only reason. So it's a difficult standard to meet in general. It's possible the California law is different. In New York State, the New York State human rights law is usually motivating factor for everything. I'm sure that there's defendants out there who are gonna, argue that maybe it should mirror, mirror whatever the federal statute is, even though the New York State human rights law has everything all in one law, whereas federal law has Title VII that has a bunch of different things in it, but then that has disability as its own thing, then it has age as its own thing. In New York, everything's all this under the same umbrella. So it's possible that in California it's a different standard, but typically age discrimination is very hard to prove because unless you have kind of overt comments, especially if you work for a big company, the age threshold is 40. So usually a lot of times the head people in a big company are going to be over 40. You're going to have a lot of peers that are probably over 40 in a bigger company. But something like this, where you can kind of say, oh, every single woman working for this company outward facing is 20 years old, then I think it's going to be potentially easier to demonstrate that this could be age discrimination and not, some other reason. Because I think the question that we ask in these types of cases and in many types of discrimination cases, but I think age discrimination would be one of the best examples of it is, when we tell somebody that they're not a good fit for the company or that they're changing their focus, like, what do we really mean when we are saying that? And we, just to sort of segue this into one of the things that this brought to mind is this idea of appearance discrimination. And we've kind of written about that on our website in a few different blog posts in different contexts. But in appearance discrimination, we don't really have that. Your appearance is not necessarily some kind of protected status necessarily, like in a vacuum. If you're a fashion model or something, like they're allowed to require you to be thin and tall and beautiful. And every company that has some sort of aesthetic component to it is allowed to at least, take into consideration what is my look and what is my vibe and whatnot. I think what starts to become the issue is my vibe and my look of my brand only 20-year-olds or only white women, or and then I think you start to run into some issues.
Yeah, and to your point earlier, I mean, it's a different scenario if it's sort of what you would describe as back of the house or, management versus like talent or front of the house. We had a case somewhat similar with two people who worked the front of a house at a restaurant and were, kind of pushed out because of their age. And it was a similar, kind of argument. This reminds me of, not to make light of it at all, I think it's Knocked Up, where Katherine Heigl's character is having the conversations with Kristen Wiig, and she's like, "We're not saying that you have to lose weight, or we're not commenting on your weight, but what I'm saying is maybe if you at home, if you weighed yourself and then you just subtracted by 10 and you just weighed that, it would be great." It's like,
That is like a great, she's so good in that movie. And I think she was like very new, like Kristen Wiig. I think she
yeah,
was like super new in that movie.
yeah, yeah,
Yeah, and I mean, so for example, so that being said, in New York City, which has a pretty productive human rights law, its own human rights law beyond the New York State with, statewide law, they have protected height and weight as a protected status. So probably in that situation, you would not necessarily want to say that out loud. But otherwise, in general, I mean, there are in the disability context some obesity cases out there. I think they could potentially go either way in the disability discrimination context. There was an Abercrombie and Fitch case that went all the way to the Supreme Court that was about wearing a headscarf.
yeah.
Somebody needed to wear a hijab for, religious reasons, and they were fired because the company, dress code and appearance code didn't allow you to have your hair covered. But that went all the way to the Supreme Court, and I think that was a unanimous decision written by Justice Scalia that said, you have to accommodate certain, religious garb unless it truly interferes with the ability to do your job. In that case, we would rather, everybody had their hair showing, was not the same type of thing as maybe in like a law enforcement situation or something where, you wouldn't be able to wear like a safety gear or something like that because of how you're wearing your hair. There are certain things that, might make the accommodation unreasonable. But, so I think people do have to be cautious, or employers have to be cautious that when they have some sort of standards of appearance, that they are remembering that they do have to make accommodations for religious reasons. They do have to make accommodations for disabilities. We can see this also implicate race discrimination. The state human rights law in New York, and I think even if it's not explicit in Title VII, you could still make this argument, does consider, certain hairstyles that are closely associated with race, like dreadlocks or braids and things like that, to be potentially implicating race discrimination if you fired somebody because you said, oh, you're not allowed to wear your hair this way, or we don't like your hair this way. And that was kind of came up. Remember, we watched that documentary with our daughter, Brandy Hellville. Did you
Yep.
watch that?
How could I
You
forget? I still refuse to go into those stores.
okay?
She wants to
So
she wants to go into those stores, for anyone listening, in every city that we go to. I think I've stood outside Brandy Melville in New York, Rome, Boston,
Miami.
Miami, Washington, D.C., and potentially Seattle. Is that
I
right?
think
I don't even
there's
know.
other places in Italy too.
Yeah. All right.
So the Georgetown one was the worst, I have to say, in terms of size and sheer claustrophobia. So the backstory of this is Brandy Melville is, if you don't know, if you don't have a teenage girl, um, is a sort of mysterious Italian company. So this is interesting to me being an Italian myself, because the aesthetic of the clothing has nothing to do with being Italian. The aesthetic of the clothing is like started off as sort of a California bohemian vibe, but is now sort of like a Abercrombie from our generation-ish, like Nantucket-y sort of collegiate, like
Yeah.
yachting vibe. I don't even know how to describe it. And I think we're a little bit too old, but apparently in the early 2000s, where we were already, or mid 2000s, we were kind of already out of law school and into like our later 20s. But for sort of teenage girls at that time and maybe early 20s girls, this company became huge, and it was actually started to become an issue with respect to girls' body image and eating disorders and things like that, because at that time they branded themselves, not that they branded themselves, their sizing was one size fits all. But the sizing at that moment in time, one size fits all, equated to a US women's extra small or small. So you can see how, there's like reports of girls, basically starving themselves in order to fit into these clothes. I don't think it's really as much like that anymore, because I think also the style of clothes at this moment for younger girls can also be very sort of oversized. So I wasn't necessarily going in there and thinking like everything in this store is microscopic. I don't understand how anyone can, fit into it. But I don't know that their issue is quite that bad anymore, but they have other issues. And this documentary was sort of about sexual harassment within the company. But one of the things in terms of age discriminate, or excuse me, appearance type of discrimination, was that you mentioned before, back of the house, front of the house, they were putting all of their sort of pretty blonde, white, skinny girls in the front of the house positions, and they were putting anybody, person of color, um, in the back, like in the storage rooms and in the, fitting rooms and things like that. And so those are situations where, you can start to say, this isn't necessarily appearance discrimination that is not protected. This is maybe crossing the line into race discrimination.
Yeah. I don't know.
'Cause in those cases, like I said,
Was there any?
you kind of have to ask yourself, when they tell me I'm not the right fit, what do they mean by that? Like when we had the case with the two older women who were bartenders, they were basically told right to their face, like, we're looking for 25-year-old girls with big, I think they literally, this was like one of those times where you could put something in quotation marks in your complaint, um, where they were literally like, we want big boobs, 25 years old, bonnet. And, somebody might think to themselves, well, what's wrong with that? And, sometimes maybe there isn't something wrong with that. But if it crosses the line
I mean, isn't
into,
that the model for Hooters?
yeah, I mean, maybe people didn't
I'm not saying
do it
I'm
or
not saying
approach it,
whether it's legal or not, but
in that way. I think
yeah.
what was a little bit different in our situation is that these people had been working there very successfully for like many years, like getting like big tips and having, like return customers and people who love them and things like that. So I think, there was a little bit more kind of going on. But I mean, a lot of stuff is not going to be able to ever prove it. Most of the time, if you go for a job interview at, a store or restaurant or something, you just either don't hear back or they just say no thanks, and that's it. And you don't have, somebody telling you right to your face, well, you have to wear a hijab to work, therefore we can't hire you.
Yeah, I mean, it's not wise to ever, we always talk about that. Just, avoid saying anything directly like that. It It's great when you're on the plaintiff side, because if somebody makes comments like that, it's typically helps prove helps lead to a stronger case. But all right, anything else on that one?
No.
All right. Brief non sequitur. I shouldn't say we, because I don't think you watch one hole, but I watched the Ryder Cup all weekend. I like to play golf. I like to play golf, as you can tell, since I'm wearing golf attire and played today. Both our kids play, and so we watched the Ryder Cup. It was exciting on Sunday. A lot of post Ryder Cup discussion about the sort of antics and behavior of some, certainly not all, of the spectators at the Ryder Cup, which was held in the Bethpage Black Course on Long Island, and how they behaved towards, in particular, Rory McIlroy, who's one of the best golfers in the world, and Shane Lowry, who's also a very good professional golfer. Um, you know, Probably crossing the line in a lot of cases in terms of, really vulgar language towards Rory, making fun of him and his wife, stuff that you kind of wouldn't expect to hear necessarily at a golf event. I did say, I think to you, this is a New York sports crowd, so it's not entirely surprising, and there's no way that they didn't think about this when they decided to hold the Ryder Cup there. I don't
Is
agree
it
with it
always
from a fan
like
perspective.
when it has been in the United States, like I felt like it was like Happy Gilmore, like when Happy Gilmore gets like his, like when it becomes like a fraternity party, like that's what it
Yeah.
looked like. Um, is it always like that when it's in the US?
So the Ryder Cup is like, for people who don't know, it rotates every 2 years between Europe and the United States who host it. And it's always a relatively rowdy from a fan perspective, because it's, your country versus another country. And there's a lot of, people wear like crazy outfits, and they get into it. I mean, it's definitely among like the more rowdy of golf's events. There is a tournament called the Waste Management, which is in Phoenix, that
Oh,
happens
my
every year.
husband
And
has for that.
yeah, and everybody goes to that. And for years, it was kind of like known about that, a bunch of kids from Arizona State would go and they'd party all day. And then there's this one hole where they would kind of like get after some of the players. It's gotten really bad over the last couple of years, I think mostly because of social media, to the point where they've had to like kick people out and cut off alcohol sales. So, you know, I don't actually know that this is people behaving badly necessarily because it's against another country. I think it's just one of those things where people were behaving badly because, they were young and stupid and probably drank too much. But in any event, where this leads from our perspective, just out of curiosity, is there was an allegation towards the end of the last day after they won, that somebody threw a beer at Rory McIlroy's wife, which is obviously crossing the line.
On video.
And somebody, what?
It's on video.
Yeah. So then the question somebody asked is, is this is this illegal? Is there anything she could do about it? Not that they're going to, because you know, if he did and he ever came back to an event in New York, he'd probably never hear the end of it. It's probably not worth it. But what legal, civilly, what legal standards or what legal claims does that potentially implicate?
Yeah, so I did a Westlaw search. There's 24 reported cases on people having a beer thrown at them. Some of them are criminal. We're civil lawyers, so from a civil perspective, like that would be, assault and battery. Probably like assault is something doesn't actually have to touch you for you to be assaulted. I think it's like something that the legal definition is different from its common definition. It's like assault and battery. The battery is actually getting touched, and the assault is the being put in the imminent fear of being touched. So, like, we have a case right now that, among other things, is mostly an employment case, but is also an assault and battery case. And yeah, like the legal jargon is of an assault is causing the plaintiff to suffer apprehension of immediate and harmful conduct. and the battery is the intent of, inflicting offensive bodily conduct and actually contact and actually causing the contact. But yeah, I mean, that's not cool. Why are you throwing a beer at like some wife that is there supporting her husband? Feels yucky. Like, I feel like a lot of stuff that was happening there was a little bit icky. I won't get too into it. There's like a whole article right now on that's going around about how she was targeted, being sort of emblematic of some things that are going on, like against, women and what's becoming kind of publicly okay. I don't want to, I don't know if it's too deep, is that going too deep? Like, I don't know. I mean, sometimes I observe stuff like this and you do start to go a little bit down the rabbit hole of like, is this all in good fun and it gets out of control? Or is this indicative of sort of a deeper, like, is there a little bit of a deeper, like more, sinister sort of undertone of like the angry mob? But I don't know, I wasn't there. So maybe it wasn't an angry mob. Like maybe it, was people having fun. But it seems to me that at least people in the golf community afterwards were like, no, this was not all in good fun. Like this crossed the line. This was embarrassing to our country and the sport.
Yeah, I mean, I have a couple of
You're
comments
like,
on this.
no, it's
Number
totally
one,
fine.
no, no, no. Number one, I think in the realm of golf, it went too far. Golf is supposed to be a gentleman or gentlewoman's game, and it's similar to like tennis, where you expect some measure of respect. And he even said, I thought Rory McIlroy had some good comments about it. And he even said, look, you can say literally whatever you want to me before I'm hitting my shot, but when I'm in my process, let me hit it. Which honestly, you're there to watch a professional do the thing that they're the best in the world at. Like, let them do it, right? Um, that's A. B is, uh, I had a friend who was there the last day and said, nobody covered it, but the European fans were actually getting on the American players pretty bad as well. And that didn't really get any coverage. I
Yeah,
don't think
and I'd
it's
be
look.
curious, like when it's over there, do they have the same things? And I mean, we talked
It's
about this, like there's many sporting events, obviously, in this country and in other countries where people are literally being like trampled to death and people are behaving like completely crazy. And yeah, obviously that didn't, happen here. So I don't want to make, I think social
no.
media, again, as we touch on all the time, tends to make everything a little bit more intense than maybe it is for the people who are there. Like this comes up in like, people think like certain cities are a war zone. And then when you're there, you're like, no, it's not.
Yeah, but that to your point about cities, I said to you, I've said to a couple people, if people look, I understand the sort of broader discussion about the state of discourse in the United States. We don't need to get into that. The only thing I'll say is that our son is 15. When he was maybe 8, I took him to a Yankees game, a playoff game, and we got there really early because he wanted to go to batting practice. And we're sitting in batting practice, and there are maybe 30 people in the bleachers at Yankee Stadium. And the drunkest guy I've seen in a long time is bouncing around the stands. A woman near me catches a fly ball, a home run ball, and the guy tries to fight her to get the home run ball and gets kicked out by security in front of us before the game even started. And I was like, Miles, these are New York sports. Welcome to New York sports. So look, yeah, I mean it's bad. You know, stuff was said about it. I think there's always a couple bad seeds. You know, if you ever go to a baseball game or a football game or anything in some cities, you see all this stuff. So, and it's against local hometown, you know, they say this stuff about their favorite team's players, let alone, another country. So,
Yeah, well, we went to
I don't think this is the thing to overthink. That's my opinion.
we took the kids to a Giants game, and I have never seen such disloyal fans. They were like, first of all, I think that provided 90% of the entertainment for our kids was listening to the people behind us heckling their own team. And then leaving, and like every time they did something, a bad play, like 100 people would get up and walk out.
Yeah, well, in their defense, I think the Giants quarterback got sacked 9 times that game, so they were warranted in their being upset. All right, so that's we'll leave it there on that one. Anything else for today?
No, I don't think so.
All right. Okay, well, thanks for listening.
Did
Again,
people
if
see that you're
you
wearing like
enjoy the
12
podcast,
different,
please like
what?
what?
Did you feel,
It's
I was
on the
gonna say,
topic
can
of
people
golf,
see that
and
you're wearing 12 different golf logos right now?
no, it's two, but thank you very much. Um, if you enjoy the podcast, please like, follow, subscribe, share with a friend. And if you have questions, hit us up on Instagram at or excuse me, at Litigious Podcast. I did it again. All right. Thanks for listening. We'll be back again next week.